Okay. A very warm good afternoon, everybody. I am Arushi Sharma, and I'll be the moderator of this session. Before going ahead, first of all, I would like to extend a very warm welcome to Advocate Vibhav Mithal on behalf of Legal File and Legally File India. So we are glad and honored to have you here. Before starting with the session, I would like to introduce our guest speaker to each one of you present here. Advocate Vibhav Mittal is a managing associate at Anand and Anand and is practicing as an IPR litigator in New Delhi in diverse areas ranging from patent law, trademark law, copyright law to plant varieties. SOR has been an integral part of many path breaking litigation, such as Monsanto disputes and Ferry Delani dispute. SIR is a regular contributor to various publications and has written for the Managing Intellectual Property magazine, Computer and Telecommunication Law Review, Asia Business Law Journal, and has also contributed to the Indian chapter in global patent litigation. Sir is also an artificial intelligence enthusiast and is currently an MKAI associate. MKAI and Milton Keynes Artificial Intelligence is a community which is initiating open conversation about important themes in AI, for example, ethics, responsibility, fairness, etc. A graduate from National University of Judicial Science, Kolkata, Sir has also pursued LLM in intellectual property law from Boston University School of Law, and in October 2019, he was featured in National Jurist, Who's Who of Foreign Attorneys, amongst 15 prominent LLM graduates, each having been nominated by their respective US law schools. Sir, now we request you to please continue with this session. I'm sure that we'll get deep insights about the career opportunities. Over to you, sir.
Thank you so much, Arushi. Thank you for that kind introduction. Good evening, everyone. I hope everyone is doing well and staying safe during these times. I'm just going to share my screen right now, if that's fine. Start with this presentation. Is this visible?
Yes, sir, it's visible.
Yes. Good evening, everyone. So I had a discussion with the legal file and the legally filed team and decided that people wanted to understand a career on intellectual property rights. So I have prepared this short talk in terms of, and we're going to keep this interactive. I'm just going to give a brief overview. I'm going to be talking about the IPR career, and as I am practicing as an IPR litigator, I will also be focusing on IPR litigation as well. So just to give you an idea, I will, and because I understand that there are students from, I mean, there's students, the second year law students, and students who may not have studied intellectual property at this point of time. My talk would cover the following. We'll quickly cover the different types of IPR that exist so that for anyone who has not studied intellectual property, you can get an idea. Then I will touch upon the different avenues that one can pursue if you're interested in intellectual property rights. And because now I am a litigator, so I will briefly then touch about what is litigation. Well, what is litigation? You will discover as you intern and as students progress to, well, probably in your, you've already discovered in your internships a little bit. You probably discover more. My focus would be more on the side of what is IPR litigation, basically litigation in the intellectual property rights field, and how that is different from the other types of litigation that is not focusing on intellectual property rights. And then I would also focus on an area as to what can you do in college if you're interested in pursuing intellectual property rights. And of course, like I mentioned, we will keep the session interactive and I will address any questions that you may have. First off, just to something I don't know how many people would be aware. Shamnad Bashir was a very renowned scholar in intellectual property law. I had the privilege, and I am his student. I was taught by him at NUJS Calcutta. One of the things that he taught me, and as some of you might know, that intellectual property is a niche field, or people tend to say it's a niche field which has its own complexity. One thing that Shamnath sir always taught is that even no matter how complex things might be, your goal should always be to explain something that even a 7-year-old can understand. It's something that Shamnath has taught us. It's something that I try to apply in my day-to-day life. It's something that I'm going to try even for this talk to try and keep it as simple as possible. And therefore, if you do not understand something, do ask me. And that's the approach that we're going to be on the talk. Moving forward, let's come to the basics first. What is intellectual property? And this is meant for students who may not have known, who do not know intellectual property. Well, briefly, intellectual property is it's intangible property, which are creations of your mind. And for that, let me try showing this. I assume this the Coca-Cola bottle would be visible right now, right? So if we take this, for example, this is a good example. Intellectual property has different types of different subfields. You have trademarks, copyright, patent, trade secret. Let me focus on the main three, four main conceptual ones. We can go into the other types of intellectual property if someone has specific questions, but because we have students who are not exposed to intellectual property, let's focus on the basics first. So trademarks. So let's look at this bottle. Now, as you can see, the word Coca-Cola is written, right? So trademark is a mark which helps to identify or which a particular, say, the Coca-Cola manufacturer, you it identifies a particular good or service in relation to a particular mark, which means that if you see Coca-Cola written like this, then it automatically, and you may not have the bottle also, it will call a recall between the good and the trademark. This is a trademark. So that's basically a source identifier trademark. Copyright, on the other hand, relates to literary, musical, artistic works. For example, if you look at the entire logo that you can see, right? The way Coca-Cola is written, the way it is stylized, or how the entire logo is designed. This could qualify as an artistic work, which might be, which may fall under copyright act. Then let's come to another thing. The Coca-Cola itself, the black liquid that's there. This the, is a trade secret. No one knows what is the ingredient of Coca-Cola and how is it made. That is not in public domain. It is kept confidentially, and that is something of IP right which is called a trade secret. In contrast, when you have patents is something that is covers ideas. Like you have an idea of a mind which relates to invention. If you develop an invention, say in the pharmaceutical industry, you develop a new drug, or in mechanical industry, in any different industries, it covers ideas, and patent is slightly more on the technical side, where not on the litigation side is not so technical, but of course it's more interconnected with technology. It could be telecom space, the pharmaceutical space, it could be in different spaces. So just to give our students a very quick, again, broad understanding of intellectual property, trademark is a source identifier which helps you distinguish your goods or services from those of others. Copyright relates to literary, music, literary work, musical work, artistic work, sound recordings, cinematographic films, and it gives you certain levels of exclusive rights. Trade secret is something that is like we showed the Coca-Cola secret, which is it's a confidential commercial purpose but kept in a secret manner. Patents covers ideas, and you would see patents in many areas of high technology areas, and it's basically it's a quid pro quo. It's the strongest form of protection. Patents you get about 20 years, but you apply for a particular patent, you disclose how you reach that particular invention that you created, and you disclose that in the specification, and then you claim a certain part of the invention. And so while you claim monopoly on a particular invention, would propose that the public learn about your technology so that further research can take. There are other areas of intellectual property as well, such as designs. For example, I have this image where example this design refers to shape, configuration, pattern, ornament, composition of lines, or which basically appeals to the eye. For example, this is just a, excuse me? Yeah, right. So this is in terms of the, so I'll put an example. For example, like a design, like this is a fork and this is a fork and knife, and this is probably appealing to the eye in different shapes and configurations. They've created this. This could probably qualify as a design. In contrast, geographical indications are source indicators, but the difference between them is that they, in geographical indications, the quality, reputation, or characteristic of a good is tied to a particular geographic region or a territory. For example, Darjeeling tea. So these are the different types of intellectual property, and I hope students have got some broad idea. The slide is meant mainly for students to understand. I understand that intellectual property is taught at a later point in law school, but this is to give you a broad overview. The main point that I wanted to explain from here is that intellectual property is it is there are many areas of subspecialization. You can see there are many different types of IPR that exist, and they are covered by the different acts. Well, trade secret is not covered by any legislation; it's more common law. But so you have a different diverse regime moving forward. Now, what avenues do you have as an IPR enthusiast to choose from? These are there might be more paths, but these are sort of the broad paths that you can take. One is the creation and registration of intellectual property rights. For example, let's take an example from a non-technical perspective. Let's say if you're interested in trademarks, right? And someone is doing a particular business, they're launching a new business, and they've come up with a brand name, they've come up with a trademark, and they want to register it. So as a trademark agent, your job in creation of registration of IPR is that you are creating the IPR because you are convincing governmental authorities, that be the trademark office. If you have a technical background, are engaged in patent prosecution, then the patent office. If you're filing a design application, the design office. And it's filing the application for the relevant intellectual property, right? And prosecuting it till the time it gets registered. So that is one path that people take. I've defined this as prosecution and opposition. Prosecution because of the fact that you're filing a relevant IP application. Opposition because there are certain intellectual property rights such as trademarks, patents, where once you file the application, deal with the registry, then it gets advertised, and after getting advertised in a journal, public has an option to oppose, and therefore you get an opposition from different people, and then becomes a quasi-judicial proceeding where before the relevant IP office, be the trademark office, patent office, you convince as to why your mark or why your patent ought to be granted. So that is one path where you can be a prosecution, opposition, and trademark agent or a patent agent. That's creation, registration of IPR, as I've loosely called it. Second one is where you are doing corporate law in itself, but that corporate lawyer has a flavor of IPR. For example, that you are working, say for example, you're working in a full service corporate law firm, or you are working in a firm that does technology, media, telecommunication laws. And a lot of work is contractual based, but some of the basis is the underlying protection is to intellectual property rights like trademarks, copyright, patents. We discussed. Let's stick with the main big three for our students here. Then the third option is, of course, and this depends upon situation to situation. Of course, in-house positions are more broad, but in-house positions basically means for our students, it's you join as a lawyer in the legal team, in the in-house legal team of a company, and you could, for from an IPR perspective, you could probably be going in-house in a pharmaceutical company or a music label or maybe a publishing house. So you have an option of going in in-house counsel. There are very few pure IPR in-house teams, but there are options. You look around in that, and generally in-house positions are mixed also with other areas of law. Then we have, of course, we have policy, we have teaching, and then in policy issues, you're forward looking, you're sort of looking at different areas of intellectual property, and you are therefore it's sort of identifying where the law ought to change and sort of advocating for that. One area, of course, is the impact of artificial intelligence, and IPR is one area that comes to my mind, but generally it could be in existing laws if there are certain areas and certain provisions of existing IP laws that you might want to change. Of course, along with policy, you obviously have the option of also becoming a teacher. And then we have litigation, path that I am on currently. So the litigation path is that, so litigation very simply for law students would be a path where you go to court, where you represent clients and you argue before the judge, and litigation. So when we're talking about intellectual property rights litigation, it's not very different from other types of litigation in the sense that the litigation aspect is the same. It's civil suit or it's criminal proceedings. So civil suit, I'm on the civil side, so you file a lawsuit and you move forward accordingly. The difference being that in my cases, kind of cases that I work on, the subject matter is intellectual property rights rather than other areas of law. Moving forward, now, the next few slides, I'm going to cover a little bit about IPR litigation, and then I'm going to move to what you can do if you're in law school. So quickly, sort of giving you a brief idea. So we've covered in the previous slide, we talked about, just to summarize again, we spoke about becoming, you could be on the creation or registration of IPR as a patent agent or trademark agent. Two, you could be in a corporate firm in the IP team, or you could be in a TMT, technology, media, telecommunication firm working on contractual areas, but on the IP side. You could also then be in a policy space. You could be in the, you could be a litigator. Now, in terms of litigation, broadly, I mean, I think as young students in second year, third year law students, and I'm sure you must have learned the Constitution or studying the Constitution or studying CPC. This is just to quickly, not to take too much time on this, with litigation is the broad overall litigation concept. You have about 600 district courts in India, 24 high courts, one Supreme Court. The interesting part for respect to intellectual property, which is why I have this slide, is that there are certain high courts that have original jurisdiction. For our students who have not done CPC, what that means is that while yes, high court, you would understand, people would understand, district courts are trial courts. They're the court where you start the lawsuit. But for certain high courts, they've been given original jurisdiction in the sense that they are the court of first instance and trial court as far as IPR disputes are concerned. Some of these courts are Delhi, Delhi, Bombay, Calcutta, Madras, Jammu and Kashmir. And so basically the point that I'm trying to make here is that there are certain courts where when you look at Delhi High Court, when you look at Bombay, you look at Calcutta, when you look at these courts, you have to view them, of course, they're appellate courts for a lot of disputes. But if you meet a certain pecuniary jurisdiction, means money jurisdiction. It means the value of a suit. So a particular suit is valued above a particular value. For example, in Delhi High Court, it's currently 2 crores and above. And of course, if you meet the territorial jurisdiction aspect, so these students who've done CPC will understand pecuniary jurisdiction, territorial jurisdiction are all concepts of CPC. So if you meet all those aspects, then we have a situation where Delhi, Bombay, Calcutta, and all of these are first instance courts. So the IP lawsuit might start in the Delhi High Court itself. And as I have been practicing in Anand and Anand in the Delhi High Court, since my practice, my talk will sort of explain this from the perspective of the Delhi High Court. Now, what do you mean by trial court? What is it that we do? Now, I don't know how many. Well, if there are Game of Thrones fans on this talk, then I assume this picture would sort of give you an idea what it is. This, but for those who've not seen Game of Thrones, this is a scene in a battle where, in the very next scene, this person, the next immediate scenes of this are that the person is just battling with everyone on the ground. And this is from an episode called Battle of the Bastards. It's a battle where he gets engrossed in fighting with every person who's attacking from every corner. So the reason I have this image is to highlight that the trial court is where we are sort of managing the stages of a lawsuit. That's what a litigator is doing. That's what I am doing. I file a lawsuit. Supposing I file a plaint. Let's. I understand. I won't get into the different stages of a lawsuit in great detail. You will study that in law school. But broadly, you start the lawsuit by filing a plaint. The defendant, the person who's been sued, files a document called a written statement. Each party files a set of documents. So there are different stages. There's pleading, which is basically when you the plaintiff files a plaint, the opposite side files a response, then we file another response in the suit. Then you have admission denial of documents, then after that contested issues, contested questions of fact, issues might be framed by court, then you might have evidence, and then you might have final stage arguments. Now, those are the broad stages, but the purpose of this slide is to tell you that at the trial court level, where it's all about deadlines, about what is the deadline for filing the written statement, what is the deadline for filing this document, that document. So it's sort of it's sort of being on your toes, knowing the progress of the lawsuit that you're functioning, that you're working on, what are the different timelines for it, and how you have to manage. It's sort of on a battlefield. I use this image to highlight this, in a battlefield, and you're just focused on here and now and the present moment in terms of a lawsuit. In contrast to that, when you're talking about which this connects back to my previous slide when I said that Delhi High Court or Calcutta High Court, Madras High Court is the trial courts, the courts of first instance, or if you're instituting the suit in the district court itself, then it's a court of first instance, where we're focusing on these aspects. And of course, it becomes a question of facts and the adjudication of the suit. In contrast, what is appeal? The appeal courts now are different. Now, this is just to give you a perspective of litigation. Trial court, I was focused on what is my deadline for filing this document, what is my deadline for this response, what is my deadline for filing the interim injunction reply. In the appeal court, the situation is slightly different. This is the same battle that I showed in the previous one. While you had if you had that particular protagonist somewhere in the middle, trying to figure out how to sort of win the battle or how to manage the battle, and he's just present here and now. The appeals court has a far vision, and they're seeing the larger picture. So when you see the larger picture, you sort of understand that how and where, what difference, and how you see the larger picture, the approach becomes different. This was just to give you an idea what we do in the trial court level, and if supposing a suit goes to the appeals court, how are the appeal courts looking at reference? Now, the one thing that I did want to, the premise and the reason I have the slide is I understand that we understand in law school, we understand that law is sort of systems. From a litigator's perspective, would anyone like to volunteer and sort of answer this question? Maybe what would how would you define what is law if you're a litigator, if you're practicing in court? So I'll move forward. So the does anyone want to try? Right. So I'll give the answer myself. So from what the reason which this is there is that it is from a litigator standpoint, law means what a judge thinks and what the judge says on a particular day. And I understand that this concept might, and I've interacted with students before also, this may conflict with may or may conflict with how you're studying about law. But when you're looking at it from a litigator's standpoint, and when you're standing in court, it's the opinion of the judge, what he's saying on that day that matters is what is law. That's a very practical way, the practice side of way how we look at law as a litigator. Of course, there are many other different variations of law, but I intend to explain it from the point of view as a litigator. Moving forward, now what do we do in litigation as an IPR litigator? I'm an IPR litigator with Anand. So these are just a few points. Like we we're finding practical solutions for clients to the judicial process. And let me remind that practical solutions are not only found in litigation, they're also found in different sort of paths that you might take, the different paths that we mentioned. But litigation is one of the ways also because but the difference is that you are finding a practical solutions for the clients through the judicial process. Here, of course, a part of that process is sort of achieving sort of adjudication on various issues because it's come to court because there are issues on which courts have to pronounce and you have to look at it, but while that is the case you also have to look at it in terms of at the end of the day everyone comes to court for getting the legal disputes resolved and in terms of finding solutions through the court mechanism. Now, this is an important point which I think is relevant for and something that I learned through Mr. Praveen Anand at Anand and through my other seniors like Shravan and other members at my firm, is that litigation is not about going to court and trying to get a detailed judgment on each issue of law or fact involved in a lawsuit in each day. It's not like you're going to go to court every day and you're going to get the case finally decided. It's about incremental victories. You have to sort of keep moving forward step by step. And the fourth bullet, I sort of highlight what could be that moving forward. It could be getting a good order on a good order that moves the law forward. It could be, for example, if your case, for example, has been going on for some time and you're at the stage of final arguments, then you could have an order where you could get timelines set for final arguments. You could tell the court that I the matter is at final arguments and we could argue it in this much time. We actually got an order in our favor in one of our matters, in a trademark matter, where we finished the matter. We told the court we'll finish it in a couple of hours, and the final arguments were heard in a time-bound schedule. And that happens in many matters sometimes. It could also be, it could also be, for example, if some party is not following court orders and you have to initiate contempt proceedings for the students out here. Contempt means you've not followed court orders and you are going back to court to initiate contempt proceedings against a person disobeying court. Now, in that situation, sometimes we've had situations where if someone caused contempt of the court order, the contempt, the person who did not follow the court order was asked to say plant 10,000 trees or was asked to donate some money to a cancer hospital. So we can move forward in litigation even in these ways. And the broad idea is to develop a practical mindset to approach issues. The key point, and I speak here primarily from my experience as an IPR litigator, as an intellectual property rights litigator, it's important for us to understand that disputes are not, it's not necessarily always never ending, never finishing. Litigation could also be knowing, so that this is where the slide where I showed that image of the protagonist in the battle, knowing each stage of your lawsuit becomes important, sort of knowing how to move things forward. and therefore that allows you to sort of break down the entire image, sort of focus on each part and move forward accordingly. Now, this is just a few slides here about how IPR litigation is different. We interact with a different set of clients, like we covered different types of IPR. We have patents, we have trademark, we have copyright. So, patents in inventors, you can have sort of inventors would be patent, people might be applying for patents, musicians, authors, these are people who might have copyright in them. So copyright rights they might have, like they might have protection of the Copyright Act. So you meet with different set of clients, each have an element of creativity. You always learn something new. For example, if I could be practicing patent law for many years, for example, but supposing I get a case in an area of technology that I don't know about, right? So you can you have to sort of keep, you read the patent, you understand the technology of which the patent is granted, and you learn as you go along. So it's a lot of an evolving process, you learn along the way. And therefore I'd say that, pharmaceutical, mechanical patents, telecommunication, you have different areas of technology where patents might touch upon, so you're learning every day. Then trademark suits. Now, trademark suits, for example, you have Nike, and then someone is copying, passing off Nike. Then though that's a simpler case, but in the sense that that's simple, so maybe a counterfeit passing off case. Passing off, for students who, just to give them an idea, passing off is a concept where the defendant, that is the person who has been sued, is passing off its goods or services as that of the plaintiff, which means the defendant, the person who has been sued, is representing that he is somehow connected or affiliated with the person who brought the lawsuit, that is the plaintiff. So in trademark suits, you can even have a situation when you're trying to build a passing off case. To be able to understand, there are, of course, we can't get into there are decisions. There's a Cadillac decision of the Supreme Court on the passing off. What are the elements of passing off? All of you will study that when you come to law school. I mean, when you study IPR. But one aspect could be trying to understand the channels of business of the plaintiff and defendant. So this is broadly to tell you how IPR litigation is slightly different. And then these are just some of my personal thoughts, that it's a slightly a little cleaner. You're not defending criminals, so different type of clients who exert pressure are slightly different. The focus is on substantive legal issues, because there are areas of IPR where we still need courts to give certain pronouncements. If we are fortunate and lucky to be part of matters where there is law to be developed, we're focusing more on that. Then it's also, this is the third one, to give come back to the example of Nike, where it's about litigation is not only about a serious dispute. The point is that you could also go to enforce your rights. Supposing if I'm a brand owner and a trademark owner, I could be Nike, I could be Reebok, I could be luxury brands, or for that matter, and I can see rampant people infringing my trademark rights, people using my trademark and trying to create an affiliation with the plaintiff. In that situation, we therefore intellectual property in that sense, at least in terms of the trademark space, becomes slightly different, because we're not only going there to resolve and get justice or resolve substantive legal issues. Sometimes it could also be sending a message to the market that the intellectual property rights be taken seriously. This is a little bit of a difference of how intellectual property functions differently from other types of litigation. It's okay if you have some questions on this, we can address this as we move on. These are just broad ideas. This is something on the procedural side. I'm not going to bother you in that sense about, because as you come into practice or as students will learn CPC, you'll understand there are certain procedural aspects of IPR that are different from, because of the fact that IPR suits have been elevated to the status of commercial disputes, commercial suits by act that was passed in 2015. So there's been the CPC has been amended with respect to that, and there are certain procedural formalities that are slightly different for IPR, which is why intellectual property litigation becomes slightly different as a result of that. Now, coming to the key point, and from after the few slides, we'll come straight to your questions. So, is litigation, IPR litigation, what is IPR? Now, to give you a few, first, let's bust a few myths. for law students, is relevant to law students. First one, something that I was myself taught or spoken about in my own law school at NUJS Calcutta when I was there, that if you want to litigate, you must moot. I did not. I was not a mooter by in law school, but I am in litigation and I am enjoying it very well. Of course, mooting might help. Maybe there are certain benefits of mooting. It helps you research, it helps you in certain ways. But I will not say that this is a thumb rule, and this is my own personal experience. That if I want to litigate, I must moot. Simply put, another way around, that if you're not mooted, you can't go into litigation. That's not correct. The second myth, which I've heard very often and which is why I want to address with, only street smart lawyers work in litigation. Sure, being a little street smart, being a little this street smart helps you maybe in certain ways. If you've understood your fundamentals are sound, your basic knowledge is in place, it allows you to probably work slightly more efficiently. But definitely, if you have an academic bent of mind, you can still be in litigation. I can assure you that being having an academic bent of mind, being in litigation allows you to sort of be in a little bit, allows you to go in depth in a way that's different. Then the another myth is that if you're in patent, that patent law can only be done for people with scientific background. That I do not subscribe to that view personally. Of course, if you're doing patent filing and registering a patent before the patent office, you may have a situation where you might need some technical background and technical skills to convince to grant a patent. But when we come to the litigation side of it, it's not so necessary. I mean, of course, you have, if you in a team, so you have engineers working, you work in a symbiotic team, at least in Anand, that's our strength. We work with engineers and we work in complete synergy in terms of engineers and lawyers working together. We learn from the engineers and we sort of figure it out in terms of the technology. But the key point here is that it's also about this connects back to the third. This third point connects back to the point which Srinath's advice that in patent you might have a complex technology which might have a complex patent which is technically complex, like I'm mentioning, but you have to also simplify it. You have to communicate to court. So this is an instance of a senior counsel. I remember this because and I learned this in my earlier years of my career, where we were getting into a very detailed technical discussion, and then the counsel just said that you have to simplify it so that I can get across to the judge. It's something that Mr. Anand, Praveen Anand, is also very good at. He sort of simplification of complex things to articulate in a manner that can be understood is very important. It connects to Shanatha's advice, connects to what Mr. Anand does and Mr. Praveen Anand does, and it sort of connects to this point about how the myth that it is only meant for scientific background. It's not. I've done a lot of patent matters, and I do not have a scientific background in that sense. I learn along the way. Then the next 2 points, which are also important that I wanted to highlight. The litigation is only worth it if you get to argue yourself. Sure, it's important to argue. It's important to understand and learn how to argue to the judge, understanding, having a conversation. But my experience tells me that a value of briefing counsel cannot be underestimated. Before you argue before the judge, you have to know how to read a file. What is the relevant fact? What is that you must tell the judge? All of those things you learn as a briefing counsel. You learn to get acquainted with your file. It's the backbone of preparation. How to read a file, how to prepare for a matter. It's you when you know your file inside out, then you're able to if you're arguing yourself, you're able to guide the judge directly. But there's a lot to learn in your initial years just by observing and even by briefing, and not even in the initial years, as a continuous process. As you work on different types of matters, you keep learning on how to articulate your point with the judge. And as you learn to brief certain person, and then you see how you learn to read a particular file, then you brief someone on it, what you learned, and you brief that person. Briefing means explain to the person what the case are, what the facts are, what the relevant dates are, what the relevant documents are, which page number they are. It sort of allows you, and when you brief a senior counsel or you brief someone else who's going to argue in court, you discover of what you've read, how much you have to tell. And then when you brief that particular person and that person, that individual argues in court, you discover how much and how they articulate your points. So it's sort of a very ongoing learning process. And as a briefing counsel, you then, as you keep observing and reading and briefing people and explaining to people and working on your matters, you learn to, you learn little things. You discover, you appear before a court multiple times. You can figure out a little bit. You can understand the judge on certain issues. How would they becomes part of strategy. You can anticipate the opposite counsel. And as a matter of fact, you also learn not only from briefing the counsel or from the team that you work with, you also learn a lot from the opposite counsel. So therefore, there's a lot of value in briefing, becoming a briefing counsel, or generally preparing for matters. That's really where it starts, even before you argue. So if you have these notions that you have to argue yourself before you become a litigator, I would seriously question that notion. The other one that I have is, if you have a fear of public speaking, litigation is not for you. I think you learn it along. The key is preparation. The better you prepare, you will develop the confidence and argue. Litigation is about applying the law, and as long as you like that part, you should give it a shot. Now, what quickly, last two slides, in terms of what are the qualities that you might need as an intern if you're going interning somewhere, or you're an entry level associate. It's about ownership, taking accountability of your tasks, understanding the value of input and tasks taught by you. If you take accountability, you generate trust. That's helpful. Curiosity helps a lot, because if you're curious about how to research a particular proposition, you might find different ways of approaching it, maybe ways that someone else has not found to approach a particular research proposition. You need to be able to work hard. Sometimes litigation can become long hours. You have to put in the hours. You have to be diligent, you have to be thorough, and then you have to have a good attitude. It has to be a lot of positive attitude, and so that you can manage the work environment. You have to have good research skills. I think this is an important point for all law students. I think the initial years as interns, and even as an entry level associate, I think your research skills are very important. It's sort of the best way to communicate your intelligence, your ability to find something. And at least I can say for a fact that, at least in my initial, well, I can't say initially, even now, sometimes when we get a tough research, I end up doing, and I also try looking upon it. But even in my initial years, even as an intern, especially, and even in my first 2 3 years at Anand, every time there used to be a research, I used to be given that task, because it sort of, it the value of being a good researcher as a law student, and the ability that you can communicate through that is immense. We should, and in research, how you would do it's different for different people. The key there is, and I say this is only that it connects with what you're looking for something. How are you, and it connects to curiosity. How are you attacking the proposition? How are you looking for what you're looking for? And then a few last 2 points, that if supposing you are an intern or even an entry level associate, if your opinion is sought on an issue, always back it up with research. If anyone is asking for an opinion, it's something that has played a very helpful role for me, at least in terms of my time at the firm, is that every time an opinion is sought, if I did not know something about it, I did not express my views till I had read upon it. I only spoke on something when I had read up on that area and when I knew. I don't have to be an expert, but enough to be able to articulate a viewpoint and sort of give my own take. And then, of course, like I mentioned in the previous slide, you're learning you're learning how to read a file and everything. And then while you're learning to do the tasks, you also simultaneously learn how to develop and how to read a file. So you manage to do all of that. You sort of do the tasks that are given to you and learn to get onto your matter. That's something that is more relevant when you join as an entry-level associate somewhere. But even as a law student, if you're helping in certain matters, if you have the privilege and interns, then and it could help. But that's how it works. Now, coming to the final slide. What can you do in law school if you're interested in IPR? So you can develop uh, so you can develop an IPR flavor to your CV. You can pursue IPR online courses. You can try writing and publishing on IPR issues. You can try writing a blog. If you have electives in your college, you can do that. Do anything, everything that is connected to IP. The key here is that it should interest you. If you're interested in intellectual property, there are enough online courses now, more than what they were at the time when I was in law school. And if you have curiosity, if you're interested in IPR, you can look up these few courses, and you'll find ways. There are enough ways to do blogs, courses, and if you have questions on this, we can figure this out. And then these are just broad thoughts that when you sit for an interview in a niche field like IP, your interest becomes evident. When you're sitting, you're coming to a niche field like intellectual property, your interest will become evident from what you're doing and what you've done. Could be online courses, could be different things that you've done. Then one another thing is that IPR firms may or may not come to law school to recruit you the way other law firms or do. So you need to be aware of, and you need to do your own research and sort of exist in research to figure out what is out there. And this connects back to the first slide that I said, different paths. You want to get into trademark prosecution registration, you can look at firms that do that. You want to be on the technical side, you want to do patent prosecution, you that you want to be you have interest in corporate law, but you're also interested in IP. You could look for firms that are doing corporate law with an element of IP. You're interested in telecommunication technology, sector. You could look in that area. So it's about what you want to do and how the element of IP mixes with your interest, and sort of then go along with it. And one thing that is though true for IPR is that you must intern. And my piece of advice is intern start off with a small or medium sized firm first, and then once you get an opportunity and when you worked a few times or you studied IPR a little bit, it would then maybe come to a firm like ANA, because what happens is that if you come to a firm like Anand and Anand or any other big firm, you would, and you've not studied intellectual property, then it's great that you have that internship opportunity. What might happen is that the quality of work that you might do might get compromised, because supposing if someone is asking you to do research and you not say I'm asking for research patents and you've not done patent law, then while I might still give you the research, I may prefer to give it to someone who's done patent law, or someone I'm looking for research trademark law, I'll give it to someone who's done trademark law. So the impact would be more in that sense if you've studied it, but it's not mandatory, it's a suggestion. And of course, if recruitment does not work like corporate law, you might need to stretch to fifth year. I mean, personally speaking, from my own personal experience, I graduated from NUJS in 2013, April 2013. I got my job at Anand and Anand in March 2013. So most of my fifth year, I was sort of working, studying, and I didn't sit for corporate law placements in that sense, but I got my job till the fag end. The point is, you have to sort of uh, reach out and take your time, and it works differently from other areas of law. So you have to figure it out. I think the key here is to know and keep exploring and to have an open mind. And of course, including your IP subjects, you of course have to keep doing well in your studies and have an overall grasp of your subjects. I think that sums up my presentation I've taken, and I'm more than willing to now take as many questions as people would like to ask. I will just stop presenting, please.
Hello, sir.
Yes,
Yes, sir. Sir, my name is Himagan Malik. Sir, I had a question regarding IPR law.
yes.
Uh, Sir, so actually, when we speak on intellectual property rights, we always forget about GI tax. So, could you? I think it's a not it's a side which is not very looked on. So, could you elaborate a little bit on that?
Sure. So as I covered initially, I just mentioned, because the understanding is that the students were very diverse, and and the students who second law students, I briefly touched on geographical indications. Geographical indications are indications, for example, let's just give an example: Darjeeling tea, right, or Tirupati laddu, right. So the point is that it's basically indications that indicate a particular reputation, quality, or other characteristic of good which originates from a particular area. That's the concept. right? Like Darjeeling tea reflects that it is tea that is grown in Darjeeling, and the fact that it is grown in Darjeeling renders the tea coming from Darjeeling particular quality. It gets its reputation from that. If your question is in terms of geographical indication, in terms of what are the paths available to you for geographical indication, then it connects back to the same slide that I had. Is that the paths are the same? You could also be you could assist in depending on your skill set. You could assist in getting GIs, geographical indications, registered before a IP office, before the geographical indications registry. If you have a client who already has registered geographical indication, then you could move, and then you could have be filing a lawsuit to protect the geographical indication under the relevant act. And the path's the same. You could, if you're interested in GI, you're not probably working in a law firm, you're not working in a, you're not on the filing side, you're not on the litigation side, you're interested in writing about it, then you could also have it on the policy side. So it's the parts are the same. It's just the subject matter, the subpart IP changes. I hope that answers your question. Thank you. I hope you're doing well, Mrs.
Yes, sir. Sir, so can I follow up on that question?
Sure.
Yes, sir. So as per the act, it says, and even in the application process, it says an association of people is supposed to do it, correct?
Correct.
Yes, sir. So I'm just confused as to such because as per my understanding, a GI tag is somewhat of a trademark, but a lot of people can use it since it comes from a particular geographical location, correct?
Correct. Comes from a geographical location. So the applicant could be an association of persons, right? So trademark, how would I make it different from a trademark? Say for example, we get this example of Coke, right? So Coke, or KFC or anything of the sort. So you could have licensing in trademarks. Trademarks is a source indicator. GI is also a source indicator, but the difference in the GI, if you go into the definition, is that it is the quality, reputation, or characteristic which is tied to a particular region, particular territory, or a locality of that territory. Right? The attribution of that is with respect to that particular tied to that territory. Right? So Darjeeling tea is Darjeeling tea for a reason because it's grown in Darjeeling, right? And you would have an association of persons in Darjeeling who would apply for GI tag, right? So that's again, and being grown in Darjeeling, it renders a particular quality like that.
Yes, sir. I got it.
Thank you.
Any other questions and queries?
Arushi, I also like to ask a question, if that's okay.
Yeah, yes, please go ahead.
Hello, sir. Very good afternoon. Sir, I have a
Your
question.
voice, Saurabh, can you please speak loudly?
Sure. Am I audible?
Yeah, you're not audible.
Am I? Is my microphone all right? Can you hear me now?
Yeah, we can hear you. Please proceed.
All right. Sir, I have a question. For an ITR enthusiast, what are the key areas that we should look upon before jumping on board so that we can avoid some certain gray areas?
I'm sorry, I didn't understand the question. Can you just, what are the three key areas before jumping on board? I can you just repeat the question, please?
So, for an IPR enthusiast, what are the key areas that we should look on before jumping on board?
Well, key areas that you should look on before jumping on board. Uh, I mean, I think that depends from person to person, right? I think intellectual property or any other area of law that you want to pursue, whether it be corporate law or tax or any other area of law, as a matter of fact, it has to be whether you have an interest in that area. It's difficult to, I mean, for me, I can speak from my perspective. My interest started because I really enjoyed, I used to do a lot of plays in school and in college, and I had a little bit of interest in the theater side. And when I learned copyright law, it sort of made me realize there's something I'm doing, and there's a legal regime around it. My interest got sparked by that. I think it's very difficult to sort of pinpoint what and how someone's interest in IPR can get inculcated, but um, I think one has to be, you have to enjoy the subject matter. You have to at least enjoy the subject area. You have to enjoy maybe the fact that you know you the what I say about intellectual property very often is that, if you know that it exists around you, then you see it everywhere. If you know the concept, right? Supposing tomorrow you know about intellectual property, trademarks. You're sitting, you're wearing slippers, maybe you're wearing Crocs, that's a trademark. You're drinking a Coke, that's a trademark. You're popping a pill or something like that, that could be covered by a patent. You're sipping tea, just discussed, that could be Darjeeling tea, which is GI. So I think it's sort of a personal thing in terms of the thing. I think it has to be the academic interest, your own interest in terms of maybe a particular industry that IPR touches that might interest you.
Thank you, sir.
Anybody else?
Hello. Sir, I'm having one question. Sir, generally I want to know what is difference between patent and copyright. I mean, more or less both are same terms. So what is difference between them?
No, so patent and copyright are very different. Copyright protects, they're protecting artistic. So let me give you examples. Let's not use statutory language. Explain this simply. If I am a author, right, and I'm writing a book, right, then say for example I'm writing a book. So I'm an author and as a publisher I write the book. So I have copyright over the literary work, right? Or supposing I am doodling in my notebook. I make a drawing, a sketch. I'm an artist. I make a sketch in my notebook. That by itself is an artistic work which becomes a copyright, right? Or I am music composer, for example, and I have those graphical notations that we use in music books, right? That qualifies as musical work, which is again qualifies as a copyright. And in copyright, I have exclusive rights to do something. It's a positive right, right? I might be an author. I have the right to. And so the I'm the author. Maybe the rights might vest with the owner. There's a distinction between author and owner in copyright. I won't get into that. Let's assume for the sake of this example that I am the author. I wrote the book, and I am the owner of copyright. Right? Let's stick with that example for now. So I have the right, whoever is the owner of the copyright will have the right to reproduce it. You look at section 14 of the Copyright Act, or let's not get into section, let's keep this simple. You can reproduce the book or the work, you can distribute your literary work. So you have positive rights that are given to you by the Copyright Act, and there are 4, 5, 6 types of work that are given copyright protection. In contrast, patent is more on and copyright protects expression of an idea. Patent, on the other hand, well, abstract ideas are not protected, but let's say broadly, from a student perspective, patents protects ideas. You've come with an idea, you've articulated enough in a patent application, and you filed a patent and you claimed a monopoly on it, right? And therefore, it's the strongest form of right. And then patent is very different from copyright in the sense that copyright is positive rights to stop you from reproducing, distributing something. Patent, on the other hand, is a negative right. If I have a particular patent, first is the strongest form of protection, right? It's about 20 years. You disclose your invention in a patent application, a granted patent, and you claim monopoly for 20 years. Copyright, on the other hand, is life plus 60 years of different works, is different variation, generally is life plus 60 years of the owner of copyright. So patent is an exclusionary right. Exclusionary right will prevent me from doing something. If I have a particular patent, if I've made a particular drug, or less drug, let's say insecticide or something of that sort, and I have a patent on it, then I can prevent someone from manufacturing it, from using it, from selling it. So those are rights given to me by the statute. And in a very simplistic way, patent might protect the idea, not abstract ideas, but let's call it ideas. And copyright is protecting the expression of that idea. So the two different types of intellectual property. They're not similar. I hope that answers your question.
Thank you, sir.
Yeah.
Is there anyone else? Any one of you has any questions or queries related to IPR or even any career opportunity as well? So it was a very informative session. I feel every question and queries have been answered while the session was going on. Thank you so much for this session, sir. I think it was very informative for all of us. It was very insightful. And
I have a question. I have a question.
yeah, please go ahead.
Sir, currently I am in my fifth year of college. So, because of the pandemic, I was not able to do any internship in the IPR field. Before that, I had done my internships in the conventional fields like the criminal and civil laws. And I had studied IPR in my eighth semester, fourth year. So, now I want to pursue a career in IPR. So, how should I go forward with it?
I mean, I think one thing that you could, if you're interested in IPR at this stage, if you're in your fifth year, right? So one way could be that if you're not getting an opportunity to intern, you could probably pursue some online courses and then eventually decide what side of IPR you want to work on. If you want to go towards trademark prosecution side or litigation side, just look up, just find law firms and apply, or apply to law firms. Just figure out which element of IPR that you want to do, and sort of like we discussed earlier in the presentation, that you should pass that out there. Anything that might suit your interest, whether it be on the policy side, teaching side, litigation side, or sort of litigation side, or filing side, anything that suits your interest, sort of researching for what options are out there and applying to them accordingly. And maybe if it helps, if there are certain courses, maybe you could do it depends, right? It'll depend upon which place you apply to, what kind of people they're looking for, and what kind of work you've done so far. It's not like you have a you'll be immediately at a disadvantage of having not done it. There's a particular anything else that you would have done in your 5 years that stands out, maybe publication, writing, anything of that sort. Then that will help you sort of in your application. The key thing here is that I think you have to have some sort of clarity in terms of which of the entire gamut do you want to apply and what is it that you want to pursue in that direction. And the last point I want to say is that don't worry about if you've not done it. Whatever you've done, make use of that. And if there's anything else that you could do while you're still graduating out of college, you could focus on that.
Thank you so much.
Anybody else? It's a good time to ask questions. Anybody? So again, thank you, sir. I
Thank
would.
you so much. I'm very grateful. I'm glad to. I hope this is. If you have any follow-up questions or anything, if people write to you, you can communicate it to me. That's absolutely fine. And thank you for this opportunity. I hope everyone's doing well and safe. And I hope everyone got a broad idea, because I had a discussion with Damini on this also, in the point that it's about trying to understand what intellectual property is like. I understood there are students who predominantly second-year students, people who've not done intellectual property. So we've tried to sort of give a very broad overview of how the field functions, a little bit more focus on IPR litigation. I really enjoyed this, and thank you so much. And
Thank
I wish everyone the best of safety and health, and everyone please take care and stay safe. Thank
Thank
you.
you, sir. I would now like to call Damini Sharma, founder Legal File, to give a vote of thanks. Damini, over to you.
Hello, Arushi. Am I audible?
Yeah, you're audible.
So, thank you so much, sir. You actually agreed on a very short notice. And thank you so much for this session. I think that was very, I think that was very insightful. And first of all, I would like to point out that the man behind this session, and the one who is actually live streaming the whole event on YouTube, the technical head of Legal File India, Mr. Sarthak. Can we have him? Can you please switch on the camera, Sarthak?
Yeah, hi.
Hi, Sarthak.
Hi.
Yeah, so we can actually see the background that is working, and he's the one who was actually live streaming the whole event on YouTube, sir. So thank you so much, Sarthak, because without you, I do not think that this would have been
Uh,
possible. the whole Google Meet and the whole technical work. I was not aware of this. Thank you
Yeah.
so much. And thank you, thank you so much, Arushi, the moderator for today's event. Sir, I would like to tell you that she's not even a part of Legal File, but she agreed on a very short notice to moderate the session because the moderator, Ms. Takshima, she got some emergency in her home, so she had to leave. So Arushi agreed on a very short notice. Thank you so much, Arushi, for sparing your time, and you actually moderated the session very well. Thank you so much once again.
Thank you so much, Damini.
And I would like to thank all the participants who actually registered for the same. And I hope that the session was very helpful for them. And I can see in the chat box there that they actually enjoyed. So we'll provide the feedback form also for, like, they can tell us whatever they were expecting. And yes, thank you so much, everyone. And thank you so much, sir, once again. So I would like to ask the participants if they want to say anything.
Hello,
Yes.
am I audible?
Yes, yes, ma'am. You're audible.
So, good afternoon, everyone present here, and our guest, Mr. Vibhav Mithal, and to all the participants. So, firstly, I would like to say that it is an honor for me to have an opportunity to give vote of thanks. So, I hereby extend my hearty vote of thanks to our speaker, Mr. Vibhav Mithal, who through his presence have made the entire webinar interesting. So the knowledge shared by our speaker, Mr. Vaibhav Mittal, would truly be proved useful for all of us. So thank you so much once again, and I wish you a very happy new year. Thank you so much.
Thank you, everyone. Thank you, Damni. Thank you, Arushi.
Thank you
Thank you,
so much,
Sarma.
sir. Thank you so much, Upasna. Thank you so much, Arushi. And thank you so much, everyone, for joining. So now you all can leave. The session is over. And if you want to see it again, you can actually see it on YouTube. I'll share the link with all of you.
Okay. Thank you.
Thank you so much, sir.
Thank you.
Thank you, everyone.
Stay safe.